Welcome to our webinar on crisis planning for Medicaid home care. New rules, as you may know, that are going into effect on October 1 of this year. And these are new rules passed as part of the governor's budget. April 1 was the date that got passed, but because of the coronavirus, there was a delay in the effective date. And so we are looking at an October 1, 2020 effective date. We have done a prior webinar that if you haven't viewed it, you may want to, which lays the foundation for Medicaid home care, the current rules, how those current rules work. We're going to review a little bit of that today, but it also gets into more of the medical changes, and we'll talk a little bit about that at the end. But the focus today is going to be on the financial model, and what we're going to see is a changing dynamic in qualifying for Medicaid home care benefits. I do want to emphasize this is crisis planning. If you need home care now, as always, if you're out in front of the curve, look at long-term care insurance, look at a Medicaid asset protection trust, the advanced planning that you may want to engage in. But if you need service now and you want to get that service in the home, then today's program is going to cover what we have today and what's coming and what we'll be dealing with on October 1st. This is our staff of attorneys, and we have upstate, downstate. We have 6 attorneys here in Albany now, and we have 3 attorneys and an up-counsel down in New York City. So our firm, Pierro and Strauss, does estate planning, elder law, and business succession planning, primarily with guardianship litigation, estate litigation included. And this is a quote from New York Legal Assistance Group, someone that I respect very highly, someone who has been part of our firm's elder law forum for many years, Valerie Bogart. And Valerie and NILAG are advocates, the best in the state and sometimes the best in the country. They fear that the Medicaid cuts that we're going to talk about today are going to severely impinge on the rights of individuals to stay at home, live independently, and get care when they need that assistance in home through Medicaid. So NILAG has ongoing resources, and as we approach October 1, it's something we refer to. So you may want to write that website down, nilag.org, and as time goes on, they will be publishing their own insights, which are very valuable to us and to you. So I would highly recommend that website to you. So what we're looking at here is an October 1 effective date, as I mentioned. It could be extended, but we are now in phase 2 here in the capital region, phase 1 in our New York City office. So we are anticipating, unless there is another spike in the coronavirus situation, that we will have an October 1 effective date, and we'll be monitoring that along with the other nuances, and we'll go through some of the things that we don't know, open issues. We know what we know, right? We don't know what we don't know, but sometimes you don't know what you don't know. We know what we don't know. Anyway, Donald Rumsfeld said that somewhere along the line. And the next slide talks about the baseline. Where do you have to get your assets and income down to in order to qualify for Medicaid? And for this, I'm going to turn it over to our esteemed senior associate attorney, who is our Medicaid specialist, and that is Frank Hemming. Frank?
Thanks, Lou. So numbers here in front of you, they're talk about income and assets. We always have to talk about income and assets whenever we talk about Medicaid. So since we're focusing on the home care rules today, we're going to try to stay in that avenue for all this. They're in front of you, so let's go over them quickly. So if you have an individual at home, so it could be mom, dad, sister, brother, child, whomever, right? If we're trying to get Medicaid for a single person, for income purposes, they're allowed $895 a month of countable income. If there's 2 people at home, so mom and dad, for example, they share the same household, you can't just double $895, that makes too much sense. So the number they actually use for that is $1,304 per month. That last number on the top, that MMMNA number, that talks more to the nursing home, but essentially that means that if someone is in the community and they're not on Medicaid, under current rules, they get $3,216 a month of monthly
Spouse.
The spouse, the well spouse gets $3,216 of monthly income. And then for assets or resources for one single individual, you get $15,750 or less of countable assets. Again, if it's a couple, it's slightly higher, but we don't double the number. So for a couple, it's $23,100. And then again, if we have that community spouse, so someone not receiving Medicaid services, they get just shy of 75,000, up to a spousal share up to almost 129,000 under current rules, but that's changing. So we're going to talk about that a little later.
So if you're taking copious notes and furiously writing right now, stop. Because these numbers are all contained in a Medicaid guide that we have made available to you, and you can get the materials from your toolbar right here, and these are also on our website at pierrolaw.com. So what you want to look for is the 2020 New York State Medicaid Guide, and that contains all of these numbers. For the beginning of the presentation, Frank, we're going to focus on the home care numbers. Income of $895 per month for a single individual, and assets of $15,750. Again, we have a lot of videos on our website that go back and trace all of these Medicaid numbers and do it in a little more detail, a little slower. Today, we want to focus on the changes. So we're going to start with a quick example that Frank's going to give you.
Sure. So let's talk about the penalty, kind of what it is, what it looks like. So let's say we apply for Medicaid. We're dealing in a scenario where we're into the new phase where there is a penalty period. And upon the time we apply for Medicaid, we find in our audit of the financial statements from the past 2.5 years, there was $135,540 given away by the Medicaid act.
A number we just picked out of the hat.
Yeah, really. So the way that this works is you take the total number of money that's gifted away, so $135,540 in our example, and you divide it by a penalty number. And we're going to show those in just a little bit. So for the New York Northeast region, where Albany is included, where our office is, that number is $11,295 as the penalty divisor. So essentially it's a math problem. You take how much is given away divided by the penalty number, and it gives you a result. So if you take a $135,540 divided by the penalty number of $11,295 for the Albany region, that results in a 12-month penalty. So essentially what that means is when that application is approved, the Medicaid applicant is not eligible to receive Medicaid services for 12 months. Following that 12-month period, then they get Medicaid. So let's look at why this is important. If we do all this and we apply for Medicaid prior to the 1st of October, before these new changes come in.
Medicaid Home Care.
For home care, not nursing home. There's no penalty. That's one of the best things we've been able to say in all of our education is there's no look back for home care until October. But now, if we're in October, now we have the penalty. So if we apply after October, we have that 12-month period of penalty and where someone is ineligible. And that penalty only begins to run when we submit our application and the applicant is both financially and medically ready to receive services.
We've been dealing with this penalty in the nursing home context forever. Since Medicaid really was started, that used to be, I believe in the beginning, it was a 24-month look back, then a 30, then 36. Then in 2005, the Deficit Reduction Act of 2005 changed that to a 60-month look back. So for nursing home Medicaid benefits, if someone's going into the nursing home, we have to navigate a 60-month look back and bring in 5 years of financial records, canceled checks, bank statements, all of those records for a 5-year time period. But as Frank said, up until October 1, we don't have to bring any of that for home care. We didn't have to bring anything except current numbers. What's the current balance in that account? So now this is a true game change. And the state is doing this for a very specific reason, to compel people to spend down their own money down to that impoverishment level of $15,750 before they receive Medicaid home care benefits. So we're going to see how these rules are going to play out. But Frank, before we do, this is the chart. If you're in the downstate area where New York City colleagues practice, Peter Strauss, Clarice Phillips, Anthony Kachui, and Gia Kim, then you have a different number.
Right, so you have to look at what, like essentially what region the person is in that you're applying for. So we most often see either the number for the Albany area, so that's 11,295, or we deal quite often with New York City or downstate on Long Island. So those numbers are higher because the average cost of care for a month of a nursing home is higher. Then that's what these numbers were based on. When they did all these calculations, it was based on the average cost for a nursing home.
Very quickly, this is a long-standing litany of how these numbers came to be. But what the state settled on many, many years ago, probably 20 years ago, was they take the Medicaid reimbursement rate for the nursing home. So this does not reflect private pay rates. If you're looking at these numbers and saying, well, in Albany County, the nursing home is $14,000 to $15,000 a month, you're correct. This is 120% of the Medicaid reimbursement rate. Those were the numbers the state had. That's the numbers that they use, and that's what we plug in to our penalty. So the penalty period begins, Frank, in a nursing home case. It's pretty easy.
Yeah, it's essentially, it starts right after we get those transfers done and then cleared after the penalty period. Or if we can, we just cancel them all out. We also have to actually apply, so we have to submit an application, and we have to have that person physically in the nursing home for that penalty to run. So it's all three of those things. You have to be eligible, in a nursing home, and apply.
So now, where we're home care, person's at home, we're applying to get aids in the home, we're applying to Medicaid to provide those aids, and we have made transfers within the past 30 months. The rules, we still don't know precisely how they're going to do this, but the rules now require us to make a determination of when that person is otherwise eligible. So they're not in a nursing home, so we don't know that they're in a nursing home. We don't know if they're Medicaid qualified. The level of care requirements, in addition to the financial requirements, have to be met. So we're going to talk more about that throughout the presentation, but this is still an evolving area, and we're seeking clarification from the state on a number of issues relative to these new changes. One of them is, how will that penalty trigger be measured? So the financial criteria is what we're going to focus on today. We'll talk a little bit about the medical, but we're going to focus on finances. And Frank, we have this now 2.5 year or 30-month look back.
Correct. So one of the biggest changes that we have is we have this look back period, right? We can't just say there's no penalty for home care anymore. So starting in October, if we apply for home care after October 1st, there's a 2.5 year or 30-month look back period for any application that goes into the county applying for home care benefits. So what does that mean? Essentially, it means that the county is going to require that we submit financial statements for every financial asset that person has owned for the last 2.5 years, and they're going to audit them, just like they audit nursing home applications now. And what they look for is they look at money or finances or any type of asset that has a financial value that they can track on statements that was transferred from you as an individual to a trust, to a family member, to a child, to a grandchild, to your church. To
any transfer for less than full and adequate consideration.
Correct. And any time that they find a transfer, that goes to your penalty number, where we take the aggregate total and divide by that penalty number, just like we did a few minutes ago.
So we have this new law, goes into effect October 1. When the Deficit Reduction Act was passed, they phased it in or staggered in the distributions or the penalty calculation. So we don't have any guidance. It was put in the law in the same place as the nursing home penalty. So when we're looking at this now, we're looking at when does that look back begin and how far back does it go? And Frank, we're not quite sure, but the way it's embedded in the law right now, unless there's further change, it's going to be a cliff. So as soon as you get to October 1, as we read the law, where this section has been placed, it goes back 30 months, and that's to April 1 of 2018. Seems a bit punitive that if you did your planning back in the summer of 2018, not knowing that these laws were going to be passed, that your transfers at that point are now going to get scooped up in this new look back period. Again, we're seeking clarification from the state to see if they will extend it so that if you apply in October of 2020, you don't have the look back period, and then it would be a 1-month look back in November, a 2-month look back in December. That's how they did it when it was the nursing home change back in 2006. So far, doesn't appear that that's the way this is going to work. It's a cliff of 30 months. You apply in October, you go back to April of 2018. Another question, Frank, is once someone's on Medicaid home care, do any of these rules apply?
Yeah, or that's another thing we don't know, right? Because if you have someone on Medicaid or you know someone who's been on Medicaid before, then you know that once a year, so roughly every 12 months, we have to recertify right? You get a package in the mail from the county office. You have to provide current income, current asset information, and most of the time recertifications under current rules just sail right through because everything's kind of been in place and already approved. But now what happens if you've had a loved one who's had Medicaid already for some time, they come up for recertification, but their past 2.5 years weren't audited when we applied for them originally. Right. So there might be transfers within that 2.5-year period that now they could look back at that they didn't look back at the time of application because that wasn't the law at the time.
This would truly be punitive, and more to the point, I don't think county DSS offices are staffed to go back and do a de novo review or a new review of every Medicaid recertification.
Correct.
To try to go back and retroactively reapply the rules. I'm afraid we're going to have a 30-month look back from October 1 to April of 2018 unless we get changes from the state. But I don't think that this will happen. It's just my prediction. You take that for what it's worth. But Frank, there are certain exemptions that apply in the law today with regard to the nursing home context. And again, we have to analogize it to the nursing home context because we've been living with that for 40 or 50 years. And the penalties for nursing home care have certain exceptions that are laid out here. You can transfer as much as you want from spouse to spouse. And we're going to talk a little bit about how that plays in to planning. And there's no penalty. There's no look back, no penalty for a spouse to spouse transfer. You can transfer to a disabled child or a trust solely for the benefit of a disabled child. Again, no penalty. Sure. And we've had some amazing cases where adult children had a disability and the parent could transfer 100% of their assets to that disabled child without penalty. That trust is a special type of trust. It has to be constructed. It's a sole benefit trust, we call it, for a disabled individual. And there are also some rules that allow us to try to remediate transfers that were made. Certainly, if you made your transfer in July of 2019, and we have that 30-month look back, and in July of 2019, you were running marathons and you were healthy as could be, and you had no indication that you were going to be needing Medicaid in October of 2020, and you innocently transferred assets for purposes exclusively other than to qualify for Medicaid, there's a rule that saves you there.
Mm-hmm. It's one of those things where just because there's this rule on the books, we don't want to have that as kind of the end all be all that of whether your case is approved, right? We would much rather have a stronger leg to stand on than to go to a fair hearing and argue that your transfers were made purposely or exclusively for a purpose other than to qualify for Medicaid, because for obvious reason, everyone could try to claim that. So it's not that we can't be successful at it. It's just we have to be mindful of that's not usually the best avenue to take, especially if there are other ones available.
We have made that argument successfully. It's usually done at a fair hearing in front of an administrative law judge, or now on the phone with an administrative law judge. And that argument has to be backed up by some facts, the health, the situation. Did you render yourself insolvent by the transfers? Were your needs otherwise met? A whole series of factors go into that. The other one that's here is if you intended to transfer it for full consideration, then that's also not a penalized transfer. If you got paid back in money or money's worth for what you gave away, then that's not a transfer. And the last one is one that we're going to play on a little bit and review as a planning technique, and that is, have the assets been returned? You can gift back. And when you gift back, it reduces or eliminates the penalty on the assets that are gifted back. So hold that thought. We're going to come back to that in one of our planning techniques. So when you're facing the situation, you need Medicaid. And this has been the case for nursing home care. We have assets, we need Medicaid, we need to do something to get ourselves across the threshold to get Medicaid eligibility. How do we do that in light of the fact that we now have a look back and a penalty for home care? And Frank, this gets into a complex calculation.
Mm-hmm. We call it the rule of halves or promissory note and gift plan, where essentially we take all the numbers that we have, we put it all in a formula, and we figure out a way where we can save roughly half of the assets. And we've been, like Lou said, we've been doing this for a long time for nursing home cases, but now we have to kind of rework the numbers to make it work for a home care context.
So we use a software called Elder Docs, which is part of Elder Counsel, which is a company that I started about 13 years ago. And that software actually does all these interrelated calculations for us, but they're complex. And We used to do it on a yellow pad. Now we have software. Frank never had to do it on yellow pad because the software predated it. So when we do those calculations, the challenges here for home care, Frank, if someone's in a nursing home, it's pretty clear. They're in a nursing home.
Yes.
They're in the room, they're in the bed.
Yes.
But if someone is at home, determining the first month of eligibility to run the penalty is somewhat of a challenge, because now you're relying on some type of an assessment of the health care needs, which are changing October 1 as well, of the individual. And we don't even know what those health care new determinants are going to look like in terms of the imposition of those new standards. But now we have to make two determinations. Are they financially eligible and are they medically eligible? And you have to have both in place before that penalty will even begin to run. So these are the challenges. Let's take a look at an example. And this is the case of Bob A, nobody you know. And Frank, why don't you walk us through the facts?
Sure. So we have to give Bob some income every month. So we gave him $33.44 of monthly income. So that could be Social Security, it could be a pension, could be several pensions, whatever it is, that's his monthly income. He also has assets, like most people do. So we gave him $262,340 of non-exempt assets. So you're just gonna have to trust us, that's what he's got. And he needs health care, right? He needs help at home. If he didn't, we wouldn't be talking about this. We can't apply for him unless he needs help at home. So under our scenario, he's paying for aides 12 hours a day. He's paying $25 an hour to those aides. So if you do the math, that comes out to $9,000 a month, or just over $100,000 for the year to private pay for these aides to come in to help them at home.
Okay, so we're throwing a lot of numbers at you. We're talking really fast because we only have 45 minutes to do all of this. How in the world do you put all this information together and make sure that you're not missing anything? Well, we just happen to have a questionnaire that's part of your materials. It's our long-term care questionnaire that digs into the details of the income, the assets. It asks if you have special needs children. It asks all the questions. It's geared right in and locked right into the New York State Medicaid law. And all the questions are geared to give us information that allows us to put a plan together to do these very complex calculations. This long-term care questionnaire is in your materials, and you can access them again as part of the webinar materials or on our website. But we ask that you complete that questionnaire before coming in so that when we sit down, we can plug these numbers in and give you a very real picture of what your Medicaid eligibility is going to look like. So here's Bob.
So we start doing some pre-planning with him, right? So his family comes in, talks to us, we set them down a path. So we're going to get some things paid right off the top. We're going to have them pay his funeral expenses because he hadn't done that already. They're going to buy him a TV, they're going to buy him some clothes. He might need some other home improvements. So there's a communication system where they can be constantly monitoring his progress, even if they're not in the house with him. He needed some furniture, and he had to pay some legal fees because he needed our help. So we spent him down an additional $33,590. That brings his asset total to $228,750 after we spent him down a little bit. Then we got to look at what we can keep, right? He can keep $15,750 right off the top again, because that's what is his exemption. He's allowed to have that. So that leaves us with another total. And then we do our calculation. So the calculation comes out to say we're going to gift $135,560 to a trust that we've talked about in other programs. And then we're going to make, in addition to that gift, we're going to make a loan. And we're going to loan $77,439 to his son, Robert Jr. And by doing all this, we're going to get him qualified for Medicaid as of the 1st of November.
So let's unpack this slide. It's a lot on this slide. We send our clients on a shopping spree. So when the time comes when somebody needs care, and it's nursing home care, up until now, only nursing home care, you go and you buy whatever needs to be bought for the rest of that person's lifetime. Remember, purchases are not gifts, they're not transfers. If you've received full value for what you're spending, then you're fine. What if the person owns a home? Can you make home improvements, home modifications? Can you put a new roof on? Sure, absolutely, sure you can. If the person owns the residence, that's a big place that you can spend money down. You can prepay that individual's funeral, the spouse's funeral, the children's funerals, the spouses of the children's funerals. You can spend a lot of money on funerals, and it's not a transfer, correct, for Medicaid purposes. So there are a lot of exceptions, a lot of rules that you can take advantage of before we get to that number that we're focusing on now, which is non-exempt assets. Once you get to the number of non-exempt assets, Then we go into our formula. Then we're going to give some of that away. But when we give it away, it creates a penalty. Then we have to figure out a way to pay for the care during that penalty period until Medicaid starts. So run us through.
So we started with income of $3,442. We took out his $895 allowance because again, he's allowed to keep that. So his income every month that's usable, that has to be used, is $2,547. So based on our last slide, he's private paying $9,000 a month for his aides. That's his cost of care. We subtract out his income because that's what he's making every month. We have to figure out what his shortfall is. So his shortfall comes out to $6,453 a month. And then we have to take a look at his assets, right? We had him at a start with $262,340. We spent him down on the funeral and the burials and the TV and the other items and his legal fees. And then we took out his exemption of his $15,750, and that left $213,000 at risk. So that's the numbers we're looking at to do our calculation right there. What is a shortfall and what does he have left for assets after we do all that?
So
then we make our gift, right? We make our gift of $135,560. We divide it by that penalty number like we talked about right at the start. That gives us a 12-month penalty, so a year of ineligibility on purpose because we gave money away. You can't give money away without penalty. If there's a look back, unless it goes to a spouse or disabled child, like you said before. So we didn't have that scenario here. So we gave away money. We created a year penalty on purpose. Now we have to get through the penalty. How do we do that? We make a loan for $77,439.93 to Bob's son, and that essentially is going to give Bob an additional $6,453 a month for 12 months. Doesn't that work out nice?
And that number is calculated to pay for the cost of care during a 12-month time period. If you're doing a nursing home calculation, Frank, there's a bill comes every month, which is the nursing home bill plus the 7.2% surcharge that New York State tax on.
Correct.
But you know what that number is? With a home care situation, we're going to have fluctuating costs of care. Each month may be different.
Correct.
So trying to structure a formula calculation and calculate a promissory note has new challenges for home care. We're going to talk about how to meet those challenges, but think about the fact that someone's at home, they may need 12 hours a day tomorrow, they may need 24 hours a day next week, they may go back to 12 hours the week after. It isn't a consistent bill that you get from a nursing home, it's a fluctuating necessity of that payment. So in this case, we did a static calculation. The cost of care remained $9,000 a month for the full 12-month time period. And that math is pretty easy.
Yeah,
actually. And we obviously jiggered the numbers to give a 12-month time period. But this is what Bob saved.
Right. So we got $135,560 to his trust, right, where it's protected, it's off the table. It's there for his family. We saved his $15,750 allowance, right, that's just sitting in his bank account. He's allowed to have it. So we'll let him have it. We prepay his burial. That expense is something that was coming at some point. It's just a matter of who's paying that. So we got that off the table too. It's one less Bob or his family have to think about. And we bought him all that new stuff, that new TV, that new furniture, any of the house upgrades. So just by doing this plan, we can get him Medicaid in 12 months, and we saved him $171,000, which isn't a half bad deal.
Not a bad deal. And this is, again, the same logic, the same calculations, the same formula and techniques that we use for nursing home care, with that one very important exception. There are variables in this formula, and we have to now account for those variables. Before we do, what about Bob's income? Remember, we said he had $895 a month that he can keep, but he has over $3,300 a month of income. Does that have to get spent down? Does that have to go to the Department of Social Services, Frank?
No, we use something called a pooled trust under current rules to talk about what happens to income under current rules, right? So Bob gets his $895. He's got $2,500 and change left over as excess. He can spend it down and pay it to Medicaid if he wants. We don't want him to do that. We don't have to do that. We established the pooled trust for him, like we've talked about in other programs. We take that excess income, we pay it to the pooled trust, and the pooled trust then can pay expenses for Bob, whether that's rent, mortgage payments, food, technology, utilities, taxes, any of those good type things that Bob's going to need to still pay for if he's living at home. The question is, another one of those, we kind of know, we kind of don't. Will transfers to a pooled trust once we're into October create a problem?
Well, do pool trusts work, Frank, for nursing homes?
They don't. So
how much income does an individual get when they're in a nursing home?
Easy, $50 and the cost of their health insurance. That's it.
$50 a month is your income allowance. Here you're at home and you're keeping your $3,300 a month through the pooled trust. That's a federal statutory exception for people with disabilities. In New York, it's been somewhat uniquely carved out by case law that people over age 65 can contribute to this special trust. It's a special needs trust. They call it a pooled income trust. They can contribute their income on a monthly basis and have it come back to be used to pay for their care, which keeps them independent in the community. Not many people could live on $895 a month. So the pool trust is the lifeline that allows people to stay at home and keep their income flowing in to pay for rent, utilities, food, clothing, anything that they need over and above what Medicaid is providing them. So we're hopeful and fairly confident that the pool trust will stay in existence. Otherwise, Medicaid Home Care can't be navigated on $895 a month. Just doesn't work. So then where do people go if they're not on home care, Frank?
They have to go to the nursing home.
To the nursing home, which is a $15,000 a month bill. So that's something that we'll be looking at and following very closely. We've broken this down into 4 different plans to try to deal with that variable. What if Bob's income changes? What if the expenses change? And they almost certainly will. How do we navigate a transfer with enough income coming in to pay for all of the necessary care? So we have plans A, B, C, and D that we're going to go through very briefly. These are things that we are not doing yet because the rule isn't in effect yet. So these are plans that will be utilized come October 1. The real point here, Frank, is you don't have to worry about plans A through D if you apply for Medicaid prior to October 1. So if you're on the verge of needing Medicaid home care, if you think you may need home care before October 1st, then you need to do an assessment, look at the finances, look at the medical assessment. We can help you with that. We have our geriatric care managers, Susan Vale, Nora Barato, who can help with the medical assessment. Frank, myself, Jennifer DeRosa can help with the financial assessment. But if you're after October 1, here is what you can anticipate. So if Bob's expenses change, he's retained certain exempt assets, and we kind of skipped over this part. But if you're living at home and you're receiving home care, then your home's exempt. So we may not put it into the mix of transfers because we don't have to. It's exempt as long as you're living there. But what we will do is put it into a revocable living trust. And by doing that, it avoids probate, but under New York law, it also avoids estate recovery. So you still take a step to protect the home, but instead of putting it in the irrevocable trust, you put it in the revocable trust. It avoids probate, it avoids estate recovery under the Medicaid rules. You may put some other exempt assets into there. There's one other major exempt asset, Frank, that we didn't mention.
Your IRA. And we don't have to do anything with those because they're exempt as long as they're in payment status, which happens automatically when you hit 72. If you're not 72 yet, we just start the distributions early. So we don't have to do anything with those other than we keep them right where they are and we factor their income into our calculation when we're running all the numbers.
So we're going to take our exempt resources like the home, put them in a revocable trust. We're going to make a gift into an irrevocable trust. And we're then going to have to account for the shortfalls that may occur if Bob's expenses increase. And also, if our income exceeds the expenses, that's not good either.
No, that's the biggest problem that I immediately thought of when we heard about these rule changes, because essentially we designed the note and the payback and the loan and everything going on so that way you're just short of your monthly payments, right? We don't want you to exceed or be at the amount of care you have to pay for, because if we show the county that you can pay for it, then you don't need Medicaid, right? You have to need help. So we design your loan payments to cover basically everything but a few $100s of your monthly cost of care. But we have to set that note in place for 12 months right when we do it and we make the transfers. So what happens sometimes? People either start getting home care in the home, or sometimes they even transition home from the nursing home. And what happens, because we want it to happen most of the time, is they start doing better, which is great from a personal standpoint and from a medical standpoint. But from a financial standpoint for this, if Bob, in our example, doesn't have $9,000 of home care costs, maybe he has $6,000, well, now our note just by itself now is paying more than that. Now we have another problem. So now we got to find other ways to show that he's medically needy enough. That way we actually get that Medicaid.
So Plan A is really the nursing home plan with a side fund. And the side fund, let's say we have children who are available and part of the planning, we would gift money to the children. They would put it, we typically advise them to put it in a joint bank account. Let's say you have 3 kids, all 3 kids go on that joint bank account. Part of the money is put into that account. The rest of the money is put into the asset protection trust. The gift to the children that's in that side fund can then be used to pay the expenses of Bob. And if they're paying Bob's expenses, then they're gifting money back to him. And by gifting money back, if you remember the premise in the beginning of the presentation, when you gift money back, it eliminates the penalty on that amount of gifted assets. So we actually have a lever that we can use to navigate that shortfall or that overage. And so we will have that side fund and have an ability to gift back, which erases some of the penalty and then allows that money to be utilized with regard to the care that may be needed in excess. But now we've set a baseline for our promissory note, which is lower than it would otherwise have been, which would accommodate reductions in the cost of care. So we've accommodated the escalation of cost and we've accommodated the reduction of cost. So Plan A is a Medicaid Asset Protection Trust, a side fund, and a promissory note. And that gets our clock running and we look towards Medicaid eligibility. So Plan B, rather than using the trust and a side fund, you make it all the side fund. So this is just an outright gift. This is a bit risky for a variety of reasons, Frank.
So sometimes what happens if you give someone something? Sometimes they use it. And if they use it, then it isn't there for you. So that reduction strategy Lou was just talking about, how we have that side fund and we have it paid back to Bob for Bob's benefit. If we give everything to the kids, before Bob really needs some of these services, just as a planning strategy, before he really needs Medicaid, and then they spend it, well, now it's not sitting in a side fund anymore.
Right. So one of the mitigating tools that we use is a special type of trust. Instead of Bob putting money into his own Medicaid Asset Protection Trust, he gifts it to the kids, and then the kids create a trust which is going to be used for his benefit. That way, if the money has to be gifted back, it's from the kids to Bob, and it's a direct line, and it erases the penalty. And we have a more secure handling of the funds that may be necessary to supplement Bob's care during this waiting period, the penalty period, until Medicaid kicks in. So we have Plan A, which is a Medicaid Asset Protection Trust and a side fund gifted to the children. We have Plan B, which is a full gift to the children and a trust created by the children to manage the payment for Bob's care. What if people have more resources than we can fit into this formula?
Sometimes we just have them private pay, right? We kind of set up, we do a calculation, we figure out how much money they need to get through 30 months of private pay for whatever benefits they need, and they move everything else to a trust or outright to the kids, whatever strategy we come up with. And it's just after that 30 months has run, then they go on Medicaid. We do this with nursing home clients. Usually you have to have substantial assets to be able to pay for a nursing home privately for 5 years.
60 months.
So that's usually a much higher number than what we're talking about right now. But for lots of clients, it might make the most sense to just bite the bullet for 30 months, know your private pay for that period, and then you go on Medicaid after that.
Okay, so Plan A, B, and C deal with a single individual navigating the gift and being able to pay for expenses while that penalty period is running, or simply planning to private pay 30 months and then set aside the rest of the assets. There are other tax issues, carryover basis, capital gains issues, property issues with regard to if you're gifting real estate, if it's your residence, you've got the star exemption issue. So all of those have to be factored in, but those are 3 of the basic plans. When it comes to married couples, I mentioned earlier, you can give as much as you want to your spouse. And there are rules that govern spousal numbers. Frank was getting at these in the chart, we have the minimum monthly maintenance needs allowance, the MMMNA, which is awarded to a well spouse of $32.16. The ill spouse can actually give money to the well spouse, part of their income, to get them up to that if they're short. And if the spouse alone has income in excess of $32.16, they are asked to do a voluntary contribution of 25% of that. And this is if you're in what we call chronic care budgeting, which would apply to certain home care programs, but not all.
Correct. So it's always that voluntary contribution that always makes me laugh, because it's not really voluntary, right? If the county asks you for it, you have to pay them that.
And then we have a resource allowance that we mentioned. It used to be the greater of
Yes.
$74,820, or one half the couple's assets up to $128,640, a rule that came in under George Pataki that's been around with us for a long time. Now it's capped. So they capped it at $74,820. That's the amount of resources that the well spouse can keep, but they can refuse.
Right. This is one of the best tools we have in our toolbox for couples that need Medicaid, when we have one person that's medically needy and one spouse that isn't. So essentially a planning opportunity that will be here now and will exist into this new future that we're going towards is spousal refusal, where essentially we take all the assets that we can, we throw them over to the well spouse, we leave basically very little, if anything, in the Medicaid spouse's name. It's got to be below that $15,750 allowance. And then we apply for Medicaid, and we have the well spouse sign a document that says, I'm refusing to contribute to the cost of my spouse's care. And you can only look at their income and their assets to determine eligibility. And once we do that, they only look at that one spouse's income and assets, and that's how we get our approvals.
So we're running about 5 minutes long, folks. So if you want to stay with us, please do. We're going to be about 5 minutes. We have a few questions. If you have questions, you can post them. We'll get you answers, whether it's live today in the webinar or whether we send them to you by email. And you can post questions right in the question section of your toolbar. Spousal refusal the governor has tried to eliminate this 27 times, and it's been defeated 27 years in a row. I've been around for all 27. So, and we've lobbied against the elimination of spousal refusal for the very reason that if you have a young, healthy spouse with a spouse who now has a chronic illness, Parkinson's, Alzheimer's, one of the wrong diseases, that is going to be a long-standing expense, they may need more than $75,000 to live the rest of their lifetime without becoming a public charge for him or herself. So that's why spousal refusal has been protected by the legislature, and 0 for 27 so far, but you never know. Spousal refusal is Plan D. So we can load up the well spouse with the assets. We can transfer all the assets into the well spouse's name. We sign the spousal refusal. We file the Medicaid application. Medicaid will be approved for the Medicaid applicant. Now you have excess resources in the hands of the well spouse. What do they do with it? They create their own Medicaid Asset Protection Trust. The key there is that once Medicaid is approved, it does not have any impact. That transfer to a Medicaid trust by the well spouse does not have any impact on the Medicaid eligibility of the Medicaid spouse. So Plan D is transfer to the well spouse, file with spousal refusal, create a Medicaid Asset Protection Trust for the well spouse, something we've done in Medicaid nursing home cases for many years. So that is our Plan D, and there are the 4 plans. It's not a free lunch, Frank.
No, we have to look at everything that we have, right? We have to look at what makes the most sense. We have to design a plan. If spousal refusal works for a person and their family, right? Because we're assuming that there's a well spouse. That doesn't always happen, but there are consequences to doing a spousal refusal. So let's talk about that quickly. So essentially, the risk we run by doing a spousal refusal case or a plan is that when you refuse, the county has the right to come back after the well spouse for the amount of their excess resources. So anything above that $75,000 number that we keep talking about. So what that could lead to is that the local county Department of Social Services is going to sue the well spouse and say, you have too much money for your spouse to be on Medicaid. We had to approve them because you refused to, but now we're exerting our right to come after you for your excess.
Have you seen a spousal refusal suit since you started working here?
Yes.
One.
Yes.
So it's not happening very often. We've done spousal refusal a lot. And it depends on the county. Albany County used to be hyper aggressive. They've backed up a little bit. Long Island is a little aggressive. HRA in New York City barely makes a sound, does not file spousal refusal lawsuits. So it really is county by county, jurisdiction by jurisdiction, how aggressive they're going to be. But we've defended those very successfully. Usually they settle and you agree to pay something, but not everything. So in the worst case, you end up paying the Medicaid rate versus the private pay rate, and the Medicaid rate is about 2/3. So if nothing else, even if you get hit 100% for a recovery, you've still saved about 1/3 of the cost of private pay care. So this is going to have an impact, Frank, these new rules, on the timing of Medicaid applications, which already is a horror show.
Right, and that's kind of not going to, or taking into account COVID and the delays that have happened with people working from home and government offices not being open to their full capabilities, things like that. So under the current rules, Medicaid, the local county Department of Social Services, or HRA, depending just who we're dealing with, they have 45 days by law to process a Medicaid application, as long as it's not seeking a pooled trust. That we're talking about home care, right? If we have a pooled trust, that extends that up to 90 days. So what's the problem here? The problem is that now we have these examiners that before were looking for current assets, current income. Now they have a lot more to do, because now they have to audit 2.5 years of financial accounts. They have to basically do half of a nursing home application. So are they still going to be able to process those in 45 or 90 days, right? Hopefully they can, but we have plenty of cases now that take longer than 45 or 90 days for various reasons. It could be we couldn't get some documents. It could be they're understaffed. It could be that they have questions, they don't understand something. But ultimately, all we're doing is we're taking more information, more requirements, and putting them down in front of the government workers that work in the Medicaid program and saying, you have a lot more work and you don't have any more time to do it.
So the medical factors are changing. You don't use your own doctor anymore. They're going to have independent physicians. So now you've got to add an independent medical examination into the mix. They're going to have an independent assessor now, instead of managed long-term care companies going out and assessing need. They're going to try to come up with a uniform assessment tool to do that. But the process is going to bog down even further. If you want to get more information on the medical side of this, again, go to our video, 60-minute video that had Nora Barato, myself, and Aaron Connor, and we broke down what those medical changes are going to be in that 60-minute version of the Medicaid changes. So, Frank, we do have a fast track application, and we've been using this more and more frequently.
We do have the ability to claim or to apply for something called the Immediate Needs Program, where essentially it fast tracks the application. It requires that the county act on that application extremely fast, up to 7 days, like you're seeing on the slide, up to 12 days if we're looking for personal care services or consumer-directed services, things like that. So essentially, if you meet criteria, and they are strict, where essentially there is no one to help you and you're in a danger, but you need home care immediately, that they can fast track your application. But again, that's before the new changes. Now we're saying, not only do we have this medically needy person, but now we have to get 2.5 years of finances. We have to have an examiner look at them. They have to approve them, and we have to hope that there are no transfers to deal with. So in theory, right, if we have enough people to do the work, they probably could process something that quickly. But that's assuming we can get all the documents. That's assuming they don't find any problems. And honestly, one question I have is, what happens if we send all the application stuff in? They make some kind of preliminary approval. Then they do some of the auditing, and then they find out there's a transfer. Are they going to be able to do that? I don't know.
So we're gearing up for this, and our office does a lot of Medicaid applications. It's what Frank really was doing for the first few years of his tenure here with PCS. But we're anticipating significant issues in the application process. We're preparing for that. As I said, the immediate needs application is something that has been a great lifeline. Remember this, for nursing home care, this is not a concern, because once you apply for nursing home care, it doesn't matter if the county takes 4 months to do the application. The person is in the nursing home, they're being cared for, and they will pay that nursing home retroactively to the first day of eligibility. With Medicaid home care, there is a lag period of 4 months, 3 months, sometimes 5 months, depending upon the assessment. And during that time period, you're on your own. You're private paying for that care, and you don't get reimbursed. So we have geriatric care managers that help our clients through that part of the process, how to navigate the system. It's been complex, it's getting more complex, but you really need a guide to get through all of those concerns. What about solo seniors? We've done some programs uniquely for solo seniors, people that don't have children to deal with, children to be able to plan and do a home care plan with. This presents unique challenges, so we have some ideas on how to put a plan together. But we also had our Elder Law Forum where we learned about some unique housing arrangements, the village movement, others where seniors taking care of seniors and seniors being paired with younger people in communities where the community becomes part of the plan. And as they say, to raise a child, it takes a village. Well, to have a senior successfully age now, I think is about the same. So what can you do now? Plan early. If you can get Medicaid application done by October 1st, now's the time. If you're questioning that, you need to get an assessment. We can help with that. If you want to get planning and you're not ready for Medicaid yet, get your trust in place. Buy the long-term care insurance. Do the analysis. Get a plan that's right for you. At least get that 30 months of coverage in place. Maybe it's not the full coverage that you'll ever need, but at least then you can use that to private pay during this look back period, and it will give you time to let your plan mature. So whatever your plan is, it's critical that you do it now. These rules are not going to get better. The budget deficits and the debt that's being incurred due to the coronavirus are going to really put significant pressure on this. Again, you have materials and handouts that will supplement what we talked about today. Refer to our website for instructional videos. There's Nara and Susan. They are happy to help families that work with our firm, and we provide their services, dovetail it with the legal and financial services, and that care assessment, if you are questioning whether you need care, is the first step in this process. And there's the guides and the videos. Again, pierrolaw.com is a wealth of information. That's our formal part of the program. Beth, we have some questions, and if you can stay with us, we have a few questions that we're going to answer right now.
All right, and thank you, everyone. If we don't get to your question, we will email you the response. So replan A, if the side fund pays a bill on the applicant's behalf, is that considered a return of gift, or does the money need to be returned to the applicant to pay the bill themselves? So
in a nursing home context, payment of the nursing home bill clearly is a gift back. But in the home care context, I think your better bet, because everything's about a paper trail, Frank, when you're dealing with Medicaid applications and social services.
Thing I've been thinking the whole time since you started answering is we have to be able to prove it, right? You can pay that person directly. You can give the money back to mom and dad and have mom and dad pay that expense. The issue with that, again, is we're looking at how much money they have in their own account. So if they have that $15,750 they're allowed, we don't want money flowing back into that account. That's not safe. That just runs a new problem.
Unless you're going to spend it within the month.
Right. So sometimes it's a lot easier just to have the child pay for that expense directly for the loved one and then provide the receipt or the other backup documentation to show that that was really used to benefit the Medicaid applicant.
As long as you can tie it to the parent or the Medicaid applicant and make it their expense and make it clear it's their expense, you should be fine just paying the bills directly, and that should count as a gift back and you erase that portion of the penalty. Sure.
All right, how are 401k RMDs treated for Medicaid eligibility?
Good question. So you have two components to a 401k, 4 components to a 201k. 2 components to a 401k. You have the asset, and as long as the Medicaid applicant is drawing from that a periodic payment, your required minimum distribution clearly counts. Well, at least it does in all but Nassau and Suffolk counties, which want you to maximize the IRA or 401k, different rules. Mm-hmm. But all of our upstate counties, we're using the RMD, and that qualifies and exempts the 401k. Then you have the RMD as income.
Correct. So if we're talking home care scenario, like we did in the program, that's just additional monthly income we have to factor into our calculations. So if we have a $500 a month RMD payment that gets to be made, that's $500 additional dollars that goes into the budget, $500 additional dollars that goes to the pool trust, $500 additional dollars that can be used for the Medicaid person from the pool trust.
All right, next one. Discuss how a loan to Robert Jr., I'm assuming that's Bob's son, is allowed in the eyes of Medicaid.
A loan, and this is a good question. So when the Deficit Reduction Act passed back in 2006, it was a 2005 Budget Reconciliation Act, but the DRA brought in these new rules and the real punitive rules that said the penalty period doesn't begin to run until you're otherwise Medicaid eligible in the nursing home and you apply for Medicaid. So we had to go figure out a way to re-engineer that rule of habits. And it was done through litigation. And we litigated several of the fair hearings ourselves in our firm. Other colleagues, Michael Amoruso and other colleagues, also litigated these cases. And it's been shown that the loan, if it meets statutory definitions, and the DRA actually gave us all of the parameters, what a DRA compliant promissory note looks like. So as long as we follow the numbers, paint by numbers, and we do the note in compliance with the Deficit Reduction Act, the transfer to Bob Jr. is not a gift because it's for full consideration. It's going to pay every penny back with interest, and the interest gets calculated in. So it's a transfer for full value and full consideration. And so it's not a gift at all. The question then becomes, well, if I have, as Bob Sr., if I own a promissory note, isn't that an asset? Don't I have that value of the promissory note, and isn't that countable, which makes me not otherwise eligible? And the answer is, in the note itself, part of the DRA requirements is that it be non-cancelable, non-negotiable, no prepayment of the note. So it has been ruled to not be a transfer or an asset. And that's why the promissory note works. There's another avenue that in many states is used. It's called an annuity. And you can do a single premium immediate annuity. That would be even harder in this kind of a case because that's locking you into a very fixed payment. And in New York State, there are no short-term annuity companies that will do this.
All right.
Beth.
Speaking of states, are spousal refusal options available in other states, such as Connecticut and Florida?
Florida, yes. Connecticut, no. And this is, Medicaid is a federal program. So half the money, about 50% of the funds for Medicaid come from the federal government. The other half come in New York State from the state and counties. In New York, there's a county share. Most states don't have a county share. So because it's a federal program, states have to be within a certain guideline, the federal parameters. And we've argued this in courts all the way up to the United States or to the New York State Court of Appeals. And the federal guidelines have to be followed. However, there's a lot of room for interpretation. And the states can interpret the rules until challenged to say that they're outside the guidelines. We've done that. In New York, we're a litigious state. So we've sued New York State multiple times, not just me, but the whole elder law section of the Bar Association to enforce the federal rules. Other states have not done so. Florida, we have a lot of reciprocity with Florida. We do programs in New York, Florida Connection with their Bar Association. They accept spousal refusal. Most states do not.
Okay, who assesses the client to know how much care they need?
Great question. And that's a legal answer of it depends on when that assessment is occurring and for what purpose. So in a home care context, we like to get an assessment done before we file the formal application so that we can assemble the medical evidence. We work with the primary care physician. We put together an affidavit for the primary care physician to support the Medicaid application. And we have Nora and Susan, our care managers, do that preliminary assessment so that we know what we're walking into. Then once you apply for Medicaid, Frank, there are currently 2 formal assessments.
Right, so the first one is done by a group called Maximus, which is essentially an agency that works on behalf of the state, where they send their own nurse. They will come to the house or the rehab, wherever the Medicaid applicant is, and they will basically do an assessment that looks at, are they medically needy enough to need Medicaid services at home? So do they need help with those activities of daily living that the aides are looking to come in to help them with?
So this is the bar. So that this is to make sure that the person can get over the lowest bar of eligibility to be in the program. 99% of the people pass the Maximus assessment.
We're not usually worried about the Maximus. If we are, then we get Sue or Nora or another care manager if we're working, in a different part of the state, or we don't apply and we wait for medicals to maybe get a little worse and then we apply later.
The other side of it is assessing the number of hours of care, and that is a litigated issue in many cases. If you don't get, and there's perverse incentives for that care, that second assessment done typically by a managed long-term care company, they get a capitated payment. So they get the same amount of money, whether you're getting 4 hours or 24 hours a day of care. So well, you know what I'm going to say. Their impetus is to give less hours. And when they go to fair hearing, there's a whole study done by the NILAG, Valerie Bogart's group, and the National Academy of Elder Law Attorneys. There's a report called Mismanaged Long-Term Care. 99% of their fair hearings they lost when people went in and asked for what was an appropriate amount of care. So that part of the system is changing. So now we're going to have a new assessor. We don't know who that is yet. The theory is that it may actually be Maximus, but these new rules are changing the entire process for eligibility, the standard of care going from 2 ADLs to 3 ADLs, and the ability to do an assessment using your own medical evidence and your own primary physician is going to be gone. These are scary things. We don't know how they're going to roll out, but it's not good for the Medicaid applicants who come in after October 1st.
If the excess monies are spent for medical care, will there still be a penalty?
No, that's a spend down. You can spend down on your own medical care if you choose to. But that money spent on the medical care is money that possibly Medicaid could have otherwise supplanted.
And you don't have to spend it on medical care, right? That could be the home improvements, it could be the burials, it could be the nice TV or things like that. It doesn't have to be just spent on medical care. It's spending things for the Medicaid applicant. As long as they're buying things for them, no problem.
Right. So now this is also going to be going into the calculus, if you will. So if we have to wait 4 months for a Medicaid decision, we have to private pay for 4 months. We're paying for those medical costs during that 4-month period. That's legitimate spending. Sure.
Let's see if we can do one more here. After an SNT, Special Needs Trust, is set up for a disabled individual, how do I get the new income amount to them? And I hope I'm asking this right, according to our viewer.
Then I'm not sure what the new income amount is.
So I think I'm going to take a stab at it. So I think when we do a Medicaid application for home care, and we submit all the current financials, we do all current income, current assets, and then we also send in that pooled trust once it's been approved. So when we get the budget from the county, they're going to say what their spend down is, what their excess income is. So if we're looking at how much money goes to the SNT or the pooled trust every month, it's a budgetary decision that is made by the county where they tell us how much goes there each month. So essentially we do a mock budget whenever we send in an application to say, this is what we think it's going to be. And unless there's something that goes grossly out of whack, where there's a trust income, RMD, something like that, we're very, very close, sometimes down to the penny of what we're expecting to see. And the county just kind of confirms to us the budget that they want. And then we check them when we get to the approval to make sure that everything looks good. And then we communicate it back to the client, say, this is the number, this is what goes to the SNT every month.
Any others, Beth?
Well, we have a lengthy one we're going to answer by email, but
Okay.
that'll do it.
All right. Thank you so much for joining us this morning. I hope this hour was helpful. 45 minutes turned into an hour, but that's not unusual for lawyers, right? Listen every Saturday at Life Happens Radio, and we're very happy to bring you this web content, and we hope to see you back at a future presentation. Thank you.